Hi, good afternoon if you are on the East Coast. Good morning if you're out west. I think we have some folks who've joined from way out west in the Pacific, so good early morning to you all as well. My name is Aaron Lacey, and you're listening to the Department of Education's proposed Title IX rules, a detailed examination. While folks are still joining us, I'll go ahead and jump into some housekeeping items. This webinar is CLE accredited. That's continuing legal education. So if you are an attorney and you're looking to pick up CLE, you may have an opportunity here. We have created some pop-up questions throughout the presentation. They're not so much questions as just little things that pop up that you have to click to show that you're still attending. So if you're on for CLE, please keep a lookout for those, and when they pop up, make sure that you click them so we can track that you've attended and make sure you get your credit. At the bottom of your screen are multiple application widgets that you can use. That's what the cool kids call them. All the widgets are resizable and movable, so feel free to move them around to get the most out of your desktop space. You can expand your slide area or maximize it to full screen by clicking on the arrows in the top right-hand corner. If you have any questions during the webinar, you can submit them through that Q&A widget down at the bottom, and we have a lot of some time, we hope, for questions, and we'll do our best, even if we're going past 90 minutes, to answer any questions that we get. A copy of the slide deck. So I know some people may have noted we did not send the deck out in advance. That is in part because we were still tweaking it this morning. As I'll discuss later, you may have noted today that the department actually published the official version of these proposed rules in the Federal Register, but there is a PDF of the deck available in the resources widget or the resources list widget at the bottom of your screen. So you can pull that down even now if you'd like to and go ahead and print it out if you want to use that to follow along. I will also note if you'll save the electronic version of that PDF, there are lots and lots of live links in the PDF. You'll see them as we go through the presentation, so you can click on those and follow them to various other resources. In fact, I'll just take a moment and note we've done a couple of things here. One, the presentation itself is very content-rich. That was by design because we want this PowerPoint deck or the PDF to actually be a resource for you. In addition, under the resource widget, you're going to find a comparison document. We actually took the proposed regulations and did a red line against the current regulations, which as a regulatory guy and a lawyer, I find extremely helpful. So be sure to pull that down as well so you can see where the department is proposing to make the various changes that it's making, particularly to the sections of the regs that are being revised and aren't entirely new. Okay, you can find additional answers to some common technical questions located in the Help widget at the bottom of your screen. And an on-demand version of this webcast should be available within an hour of it being over. So if you have to go for some reason or you want to come back and listen to it again, you are welcome to do that. It's free and on-demand at your convenience. Finally, there is a survey that's available in a widget at the bottom of the screen after the webinar. If you have a few minutes and you could fill out that survey, we'd be extremely grateful. We really do value the feedback that we get from folks. As our regular listeners know, we pay attention to those surveys, and we make a real effort to improve every webinar. So my name is Aaron Lacey. I'm a partner here in the higher education practice of Thompson, Coburn, LLP. Thompson, Coburn, for those who may not know us, is a law firm. We're based in St. Louis, Missouri, have working towards 400 attorneys. So we're a pretty big law firm, and we have some of those other offices in L.A. and Chicago and D.C. and places like that as well. I am an attorney who practices in the area of higher education along with our higher ed practice, meaning my clients are colleges and universities, et cetera. My real bailiwick is regulatory counsel, so I counsel schools on Title IV, federal financial aid, Title IX, CLE Act, all those consumer information requirements, state authorization, ADA, discrimination laws, et cetera. All that stuff that's sort of unique and applies to institutions of higher education in special ways. We also work with schools in student employee litigation, government investigations, administrative proceedings, including proceedings initiated by the U.S. Department of Education, IG investigations, FSA program reviews, things along those lines. And we do post-secondary transactions, draft a lot of policies and contracts, and help folks put together compliance systems on a very regular basis. This presentation is one in a series. We have a higher ed webinar series that we've offered this year. This is our 2018-19 calendar. For those of you who may be new to us or are unfamiliar with the series, you'll see here in the screen where there are some that are underlined. You can go to them and follow those links. They're live in the PDF, and you can go back and listen to those webinars if you like, because they're all housed on our website. And then you can see we have a number that are scheduled out for next year in various different areas of the law, college sports law, intellectual property, First Amendment, charitable planning, those kinds of things. And that's me on the right doing my best impression of a podcaster. So all of that having been said, I really want to jump into this quickly. We've got a lot of ground to cover. I am going to try here at the beginning to provide some context and setup. I know that we've got a range of people on the line today. We've got Title IX coordinators, we've got administrators, we have general counsel. Some of you are going to be familiar with Title IX, some less familiar, but this is not a 101 webinar, so to speak. We are going to get into the weeds. The title is a detailed examination, and that's what it's going to be. That having been said, let's just do a little bit in the way of prelude. So, and this is going to be relevant to some of the stuff that we're talking about. Most of you probably aware when we talk about Title IX, we're talking about Title IX, the Education Amendments of 1972. That's a statute, right? Congress passed that, and it prohibits sex discrimination in the activities and programs offered by institutions of higher education. In 1975, the Department of Ed published 34 CFR Part 106, which is where all of the department's regulations that implement Title IX, I mean the U.S. Department of Education, when I say the department, all of their regulations reside. I've heard a couple of folks in commentary suggest that there have been no regulatory revisions or additions since 1975. That's not quite right. To be clear, the department has on various occasions updated or revised its Title IX regulations, but not in the area concerning sexual harassment, right? So these have been either technical revisions or revisions in areas that are really unrelated to what we're talking about today. It is true that the proposed rules we're talking about today are the first significant regulatory effort on part of the department to implement and regulate around the management of sexual harassment on campus. Now, there has been in the interim, and I say regulatory effort, a lot of other activity, meaning in the court systems and judiciary and also at the sub-regulatory level, and that's important to understand as well. So if you look at this timeline, you'll see from 79 to 82, there were some additional minor revisions to the regulations. Then in 2000 and 2006, the department had some very small additions and revisions they made to the rules. But it was really in 1997, 98, and 99, and the reason these are separate is because these aren't rules, and I wanted to sort of pull these out, that some important things started to happen. In 1997, the department published sub-regulatory guidance, so these aren't rules, but sub-regulatory guidance about sexual harassment and how schools should manage those types of incidents on campus. Then in 1998 and 99, there were a couple of really important Supreme Court decisions that came along. The first was this Gebser versus Lago Vista, right? And it held, and you'll see we say in the print, that an individual may only recover monetary damages under Title IX when a school official with authority to institute corrective measures has actual notice of the harassment but is deliberately indifferent to it. Now, to be really clear, what the Supreme Court in this instance was thinking about and talking about was the ability of an individual, a private individual, to bring a lawsuit against the institution and say, you know, I believe that under Title IX, that the institution failed under Title IX as a consequence, I should be able to sue for monetary damages. Then in 1999, in Davis, again, the Supreme Court considered Title IX, and again, they were talking about private actions for a private action by an individual to seek monetary damages against an institution, right? And in that case, they reinforced the deliberately indifferent standard and indicated that the school would be liable if it's deliberately indifferent to known sexual harassment, if the harasser is under the school's disciplinary authority and the behavior is so severe, pervasive, and objectively offensive that it denies access to the school's program and activities. Now, you don't have to remember all of that right now, but you'll see in a few minutes, I'm going to come back to this. Really what I want you to remember is this idea that from 1975 through 2006, there was a little bit of regulatory activity, right? But really nothing around the regulation of sexual harassment. And then you had this guidance in 1997 followed by a couple of major Supreme Court decisions. Okay. So subsequently, in 2000, and let me get to my next slide here. Apologies, I'm just having a little technical difficulty. I'm not seeing my own slide. I'm going to ask my producers here, guys. I'm not seeing the advancement of the slides. Appreciate folks' patience here. All right, give me 1 second. We're just having a technical difficulty. My apologies. We'll get right back into this. All right, there we go. Sorry about that, guys. Thanks for hanging in there with us. Okay, back to the Title IX timeline. So in 2001, remember we said there wasn't any significant rulemaking, right, that really occurred around sexual harassment, but you did have these significant Supreme Court decisions that happened in late in 1989 and then in 1999. So in 2001, the U.S. Department of Education put out a new significant guidance document taking into account those two decisions that we just mentioned on the prior slide. So that was Gebser and Davis there at the bottom. The department put out this revised guidance in 2001, and one of the things that they commented on specifically at that point in time is that they were drawing a distinction between the standards for administrative enforcement and standards for private litigation for monetary damages. So what I mean by that, what the department was saying is, look, when we come evaluate an institution and its management of an incident under Title IX, we may use standards that are different from what a court may look to when determining whether or not an individual who is suing a school can be successful in recovering monetary damages, right? So then after that, we had a period of about a decade without a lot of activity. And as a lot of the folks on the phone are very well aware, suddenly that changed in 2011 and 2014 and 2016 when the prior administration issued, particularly in 11 and 14, significant policy documents around Title IX and the management of sexual misconduct on campus. We had an election in 2016, and in February 2017, this administration first rescinded that May 2016 guidance and then subsequently rescinded the guidance from 2011 and 2014. So you see I've got a yellow box around those significant pieces of guidance that, as of today, have been rescinded, which essentially leaves us with what we got in 2001 and then some additional Q&A and a little bit of informal guidance that we got from the department in 2017 at the same time that they rescinded the guidance from the prior administration. Okay. So on August 29th, 2018, a lot of folks know, the New York Times leaked a copy of some draft Title IX rules. I should say someone at the Department of Education leaked them to the New York Times, and the New York Times published those draft rules, right? And then a couple other things happened in the lead up. On September 7th, 2018, the U.S. Court of Appeals in the Sixth Circuit, in a lawsuit against the University of Michigan, held that if a public university has to choose between competing narratives to resolve a case, that university must give the accused student or his agent an opportunity to cross-examine the accuser and adverse witnesses in the presence of a neutral fact finder. So there were a couple of ideas that were floated here in the Sixth Circuit case. One was this notion of cross-examination, which under the prior administration and for reasons that have been articulated, policy reasons, have been a concern, this notion that a respondent might be able to cross-examine a complaint in an incident involving allegations of sexual misconduct. But this court came along and said, look, at least at a public university, due process requires that the accused have an opportunity to confront the accuser, whether that be in a live setting or through an intermediary. There's further discussion around that. But the core notion that cross-examination has to be available to the respondent was important to this court. The other really interesting and important idea that was floated here was that the fact finder had to be neutral, meaning someone who was distinct or different from your investigator, the person who carried out the investigation, and or your Title IX coordinator. A lot of institutions, and there's been a lot of conversation around the single investigator model, meaning you've got one individual who is both the investigator and the fact finder / adjudicator. And so the Sixth Circuit here was suggesting strongly that at least at public institutions that fall within the Sixth Circuit, that was not acceptable. Okay. And then finally, this isn't a red herring entirely, but I think it's worth noting that on October 21st, again, the New York Times reported that there was within the current administration conversation occurring around changing the definition of sex to exclude what is commonly thought of right now as sort of gender, with the result that discrimination based on gender would conceivably not be covered by federal sex discrimination laws. Okay, with that as the backdrop, we got our unofficial proposed rule. So on November 16th, 2018, just a couple of weeks ago, the department published the unofficial version of this proposed Title IX rule, accompanied at the time by a section-by-section summary. And if you follow these links here, you can go to both of those documents. Let's talk about what this represents. I was actually having a conversation with a couple of folks earlier this week, and I appreciate that not everyone is a nerdy regulatory attorney and may not be as familiar with sort of what a proposed rule is and where it stands in the process of getting to a final rule. So this is what the department or any agency would call, federal agency, a notice of proposed rulemaking. Now I've got right here for you the regulatory identification number and the docket ID. The official version of this rule was actually published this morning in the Federal Register, and we've got a link here that will take you to the official version of the rule. It's almost identical to the unofficial version, but for the filling in of some dates and things along those lines. So these proposed rules would amend and add to the current Title IX rules. So just to be clear, it's not as if, again, there are no rules right now that the department has in place to implement Title IX. There are, right? Some of what the department is doing here is revising rules and language that already exist. And some of what they're doing is adding new sections where you've got entirely sort of completely formed sets of rules that will go in. But all of this essentially will be integrated into the current regulatory structure. That regulatory structure is at Part 106, 34 CFR Part 106. Interested parties, meaning anyone, has 60 days from the date of the official publication today to file comments with the department. So you've got until January 28th, 2019. Filing comments is easy. You can file them through the federal rulemaking portal. You can also mail them in. I mean, the department prefers if they get emailed in. And by the way, they like them in Microsoft Word. The reason is this administration and others, this agency, I should say, and others in the government have recently started a process. They have to review these comments. And historically, they would sort of take one document at a time and review the entirety of the document. So if you submitted comments, they'd read your comments through, right? Now what they've started doing is they'll search through these documents using software, and they'll take comments relating to similar sections and pull them all and dump them in one place so they can read everybody's comments on a particular topic or section of the proposal at once, as opposed to sort of reading one set of comments at a time and jumping around. So that's why they like to get them in Microsoft Word. They'll take them in PDF or other formats, but that is the preferred one. Keep in mind, if you do file comments, that your comments are public. They will be public from the moment you file them if you submit them electronically, and they will also be subject to review by the public on an ongoing basis. Advocates right now, lots of different people. I shouldn't just say advocates, although that is often what is reported in the press. I suppose others as well are urging the department to extend the period another 60 days. The 60-day timeline is in the Federal Register announcement that appeared today. I think it's probably unlikely that they extend it, but keep an eye out just in case they do. So what does that mean? I mean, what's the effective date of these rules? When are we going to see final rules? One of the things I really want to emphasize, particularly to the folks who may know a lot about managing sex discrimination on campus but may not know a lot about the federal regulatory process, right now it is extremely uncertain when a final rule, so remember, these are proposed rules, it's extremely uncertain when a final rule would be promulgated by the department or become effective. And those could be different dates, right? I mean, they could promulgate a rule on one day and they could designate it to become effective at even a later date. It is clear that this administration is committed to this rule, right? And of course, they understand there's an election coming in 2 years, so they're going to be mindful of that timeline as well. But there are a lot of additional external forces at play. The department is already managing an extremely ambitious regulatory agenda. They are dealing with rules around bar defense and gainful employment. They've just announced a new regulatory, new rulemaking effort around accreditation and online education and faith-based institutions and their participation in Title IV. So they've got all of these things that they're trying to accomplish. Meanwhile, the Department of Education is understaffed and unhappy. I've got links here if you want to go read some articles about it. But, and in particular, the policy folks and the folks in FSA and some of the divisions that would be working on these kinds of things are down, depending on where you read, 10, 20% from what they were 2 years ago under the prior administration. The federal union that represents federal employees right now is going after the department, and all signs are that there's a pretty significant amount of dissatisfaction. Which doesn't make it any easier to balance all these things and move forward. There will almost certainly be thousands of comments that are filed. I've been involved in rulemakings in the last couple of 3 years where there were literally 80 or 90,000 comments filed. So, and the department, again, has an obligation to read all of those. So it can take a lot of time depending on the volume of what goes in, and this is such a politically charged area that it would not surprise me if you saw lots and lots and lots of comments. The Democrats in Congress have openly and recently and repeatedly vowed to fight these proposed rules in whatever way that might mean, assisting folks to bring litigation, calling the current administration. Now that the Democrats hold the House, they have much increased ability to hold hearings and call folks from the department in front of them to answer questions, et cetera. That can not only delay efforts but complicate efforts. There will almost certainly be court challenges. I'll just tell you, almost every regulatory effort that the current Department of Ed has initiated since the last election has been or is being challenged in court at every step of the way. And finally, the department, this administration, is going to want to make sure that when it produces its final rule, that in the commentary to that rule, it is able to support and defend the rule to the best of its ability. Because if someone challenges the rule in court, one of the things that's going to be looked at and analyzed is the sufficiency of the department's justification and explanation for why it is proposing the rule in the way that it did, right? So you've got all of these competing factors that are in play around this rule and could easily impact how long it takes for this administration to potentially get the rule across the finish line. So if you're on the other end of the line right now, you may be saying, so should we even be concerned about this rule? How much attention should we be paying? What's the relevance of the next hour and 50 minutes for me? So a brief interlude for some practical advice. First of all, I want to encourage folks to read the proposed rule. It is, if you're on this webinar and you're interested in Title IX, certainly it's meaningful, and it's not that voluminous. It's, I sort of chuckle because I see the press refer to the unofficial version as going 144 pages. First of all, I mean, there have been recent rule packages like the bar defense that was 434 pages. So 144 is not bad. That's double-spaced 12 font. You're going to find that the Federal Register entry today is much shorter. If you look at the comparison document that we created and have attached here that just shows the new regulatory language, that's only 12 pages, right? So you can actually read the proposed rules and the changes to the rules very rapidly. The vast majority of that 144 pages is about half of it is commentary with the department explaining why they did what they did and you know, sort of what their thinking was. And then there's also, you know, a chunk, 10, 20% of it, that's the department doing their paperwork analysis and regulatory burden analysis, which are things agencies have to do when they promulgate rules. It's only the last few pages that actually represent the new rules themselves. So what I'm really trying to communicate is it's doable. Don't think that it's too much to get through. You can absolutely get through it, and I think it's worth your time because it is really important to comment. Occasionally I will hear people who are quite cynical about participating in the rulemaking process. But I can assure you, I mean, from past experience, personal past experience as well as professional, these agencies, the Department of Education, not only do they have a burden or an obligation to look at the rules, but they do. And they'll comment on them when they issue the final rule. And they'll say, you know, commenters said this and commenters said that. Now, they may disagree with your point, or they may decline to take, and they often do, many commenters' suggestions. In fact, you often couldn't take everyone's suggestions because they're contradictory, right? But it is important to give the department that feedback. And a lot of the folks tuning in today, you're the experts. I mean, you're really on the ground. You're at the schools. You understand whether some of these things are, from an operational standpoint, workable. And the department may not get that. And some of the most valuable comment that agencies get is when folks will write in and say, you know, I understand that what you're getting at here, and this seems like a good idea, but it is not workable. Right? This will cost us this amount of money. We would never be able to carry this out. It's going to be confusing. You haven't thought about this or you haven't thought about that. All of those are really positive comments. And remember, the comment process is easy and free, right? You're just writing out what you think and submitting it via email. You can comment individually. You can comment officially as an institution. You can also coordinate with trade groups and associations. So, you know, if you are a member of an association, if you're at a faith-based institution and you think your, you know, association for your faith-based schools, for example, has particular thoughts and wants to comment together, you can do that. But I encourage you to do it. The last thing is I do encourage you to stay engaged because it's coming, right? It may take a while. There may be litigation. There's going to be lots of press. Again, this, we all know, is a very politically charged area. It's something that really captures the imagination of folks who don't even follow higher ed particularly closely. But we're going to get there, and you're going to want to know where things stand and keep an eye on litigation and timelines, et cetera. The other thing I want to encourage folks is to not forget the big picture here. So, you know, you look at these prior slides and you think, my gosh, you know, they've got these new rules and things are in flux. First of all, as a lot of you who are administrators on campuses know, while Title IX is a headliner, sexual misconduct on campus is regulated or subject to a much broader set of rules. You got the CLE Act, you've got state and municipal laws. For your employees, you got Title VII of the Civil Rights Act. And then you may have privacy laws, mandatory reporter laws, and of course there's even pending legislation out there. So there's a lot of other things in play. I would also encourage you to focus when you're thinking about these things on the stuff that's not changing. You almost certainly have a period right now, I would suggest, of at least 6 months. I would just be shocked if we get through all of this and the comments go in and the department puts out a final rule in less than 6 months, maybe. But what that means is, you know, even while you're paying attention to what the department's thinking and sort of looking down the line, you've got a lot of really important laws that aren't changing and still govern your process. You want to make sure you're focusing on and compliant with those. The CLE Act is not changing. Right, so all of those requirements in regulation are the same, and you want to make sure you're complying with those. And then a lot of you are subject to state laws, particularly in red states, that are maybe even more aggressive than what the department is proposing here. Aggressive may be the wrong way to say it. More conservative, more liberal, however you want to characterize it. But the point is they may have additional requirements that are beyond or different from what's being currently enforced by the department or proposed by the department. And you have to comply with those, right? I was working last week with a school in New York and was drafting their sexual misconduct policy. And, of course, New York has a really robust law that is much more closely aligned with the Obama-era federal guidance than it would be with what's being proposed right now by the Department of Education. And that school is subject to that law right now. So focus on keep the big picture in mind and Focus on the stuff that's not changing. The other thing I always tell all of my clients is, keep in mind thematically what it is that's important and you're trying, most significantly, what you're trying to accomplish here. And this is always the advice. I deal a lot with complex regulations and regulatory frameworks. And, I know when you're on the other end of the line and you're an administrator at a school, I was in-house for several years, you get all these laws and this advice and you listen to a webinar like this and then you hang up the phone and you're like, well, what do we do now? And it's easy to get overwhelmed. It's easy to lose sight of the forest for the trees. And one of the things I always try to encourage my clients to do is to really focus on the core themes here. Whether you're talking about these proposed rules, the state laws, the CLE Act, or the guidance that was issued under the prior administration, there are certain key areas that were generally of concern, right? Complaint management. When somebody shows up and makes a complaint, what are you doing? And one of the big concerns was schools weren't doing enough. They weren't taking people seriously. They weren't providing them with resources. They weren't making sure they got medical and safety attention rapidly enough, right? So you want to focus on that. Confidentiality and or privacy, those are different concepts. I'll talk about that a little later. But, it's really important to make sure folks understand what their options are for reporting and how that can affect their privacy or confidentiality. Managing investigations and hearings in a fair and consistent and thorough way. And then having some real training and outreach. For a long time, a lot of schools, I love higher ed. I spent my whole career working with higher ed. I think the U.S. higher ed system is an incredible thing. But schools probably weren't doing enough in training and outreach, right? It's almost certain, I think. And even now, you're seeing this administration propose, a lot of states propose and require, and the CLE Act certainly requires, some meaningful, real, initial and ongoing training and outreach for students and employees. If you're hitting all these things out of the park, or you're at least trying in an aggressive way to make sure that you're doing these things well, not crossing every T and not dotting every I, or being a little out of step with, the proposed rule or something else is probably not as big a deal, right? So don't lose sight of the key objectives that you're trying to accomplish here, and that a lot of these rules are really focused on encouraging. Okay. So all of that being said, we're at the top of the hour, we have 60 minutes. Let's really dig into this proposed rule. I'm a top-down learner. I like to have a big picture before I start getting into details. So the green box basically represents the stuff that this is thematically what the department is proposing to do. Right? I'm not going to go through all these because we're going to walk through all of this in detail. But I wanted you to sort of visually see the green box represents the things that already are kind of in the law and the department's revising or changing. If you go to the comparison, you'll see the first three sections are sections of law that are being revised. They're not brand new. All the blue stuff basically represents brand new regs from the department. There's not something there that they're revising or updating. These are all essentially new concepts. I'm actually going to put the green stuff at the very end of this presentation because I'm fairly confident that what we're all really interested in getting into is the stuff in blue. Before we start walking through in detail the proposal, though, one of the things, and this ties back to the calendar discussion earlier where I was talking through the timeline, one of the things I really want to emphasize here is that these rules from the department's perspective represent a philosophical shift, right, in how they have believed it's appropriate to regulate and sort of think about Title IX compliance from the standpoint of an institution, right? So in Gebser, and you'll remember we talked about this a little bit about 5 minutes ago. In Gebser, the Supreme Court acknowledged that the department could promulgate and enforce requirements that would effectuate, carry out Title IX's non-discrimination mandate, even in circumstances that would not give rise to a claim for monetary damages or for money damages. What do I mean by that? What the court was basically saying is, look, if the U.S. Department of Education wants to have a separate set of standards that it uses to determine whether or not a school complies with Title IX. And those standards are slightly different from what we as the Supreme Court may say would be an appropriate basis for an individual to sue a school under Title IX and get monetary damages. They can do that. The agency has that discretion, right? And this administration, this current department has acknowledged that, as you would expect that they would, because it's about acknowledging that they have the authority to sort of go any direction they want. In the 2001 guidance, and thereafter, throughout the prior administration, the Obama administration, the department pretty consistently set out administrative enforcement standards that differed from those that the Supreme Court had articulated in Gebser and Davis and were used to determine monetary damages in private actions. right? So what we're now seeing, and if you read the commentary, the first 20 pages of the commentary, or at least in the unofficial version, it'll be the first page and a half in the Federal Register because it's very small print. But the first section of the commentary, what the department is basically saying is, we believe it's appropriate, and we are now proposing to align our administrative standards, what we, the department, use to determine whether or not a school is complying with Title IX, with the standards developed by the Supreme Court in cases assessing liability under Title IX for money damages in private litigation. And here's a quote from the Federal Register. I don't like to do this very often, but I thought this was really meaningful. So, the department believes that students and institutions would benefit from the clarity of an essentially uniform standard. More importantly, the department believes that the Supreme Court's foundational decisions in Gebser and Davis are based on a textual interpretation of Title IX and on policy rationales that the department finds persuasive for the administrative context. The department's proposed regulations, meaning what we're about to walk through today, significantly reflect legal precedents because, while we could have chosen to regulate in a somewhat different manner, we believe that the standards articulated by the Supreme Court in these areas are the best interpretation of Title IX and that a consistent body of law will facilitate appropriate implementation. The reason I want to emphasize this is because it's important to understand that a number of the phrases and definitions and sort of critical departures from what was conceived and enforced under the prior administration really since 2001, they aren't arbitrary. I'm sure people will disagree on whether or not they think the department is right in doing this. I think that there will be almost certainly victims advocates who feel like this is not an appropriate departure because it's the Supreme Court. Its standards are not as favorable, I would say, to the victim. Let's just put it that way. It's a slightly higher standard in some respects. A lot of the language that they're including here. On the other hand, I have no doubt that many schools and attorney types feel like there is some merit to this notion of having uniform standards. So in other words, you can't have a situation where the department says you didn't satisfy your Title IX obligation for our purposes, but a court would say you did satisfy Title IX for purposes of monetary damages. Now that there would be no gap between the two. From an attorney perspective and a defense attorney for an institution, that's probably something you consider as positive. The real point, though, I want to emphasize, without getting into that fray and wherever you might land, is that as you see these changes, just keep in mind that they're not arbitrary. What the department is doing is they are pulling language out of these prior Supreme Court decisions and essentially aligning their administrative standards with some of the language that was put forward by the Supreme Court in 98 and 99. So let's start with definitions of key terms. There are 6 new terms that are identified: sexual harassment, complainant, respondent, formal complaint, supportive measures, actual knowledge. I'm going to go through right now the 3 on the top and formal complaint. We'll get into supportive measures and actual knowledge later in the presentation. Sexual harassment. Under the proposed rule, this is what sexual harassment would mean. And I want to emphasize here, when I say what it would mean, I mean for purposes of a Title IX action. So for purposes, when determining whether or not you're complying with Title IX, whether or not your obligations are triggered under Title IX, under these rules, that's where this definition would come into play. This administration has said in the proposed rule repeatedly that, an institution could use a different concept of sexual harassment or sexual misconduct and could proceed with an investigation and to look into issues of sexual misconduct that fall outside of this definition of sexual harassment. But if it falls outside of this definition, it's not Title IX sexual harassment and would not be covered by these rules and obligations, et cetera, right? So the department here is proposing that for purposes of Title IX, sexual harassment would mean an employee of the school conditioning the provision of an aid, benefit, or service of the school on an individual's participation in unwelcome sexual conduct. So this is classic quid pro quo sexual harassment, right? You have someone, an authority figure, a supervisor, in this case an employee, who's saying, if you do sexual thing A with me, then I will give you B. Sexual assault, as defined at 34 CFR 668-46A, that's the Clery Act regs, right? So it's the sexual assault definition from the Clery Act regs. Or unwelcome conduct on the basis of sex that is so severe, pervasive, and objectively offensive that it effectively denies a person equal access to the school's education program or activity. So if it's quid pro quo, or if it's one of these latter bullets, either it's sexual assault or it's unwelcome conduct on the basis of sex that achieves this standard of severe, pervasive, and objectively offensive, which is out of the Supreme Court case law, then it would be sexual harassment for the purposes of Title IX. The department indicates, and this is out of their summary that accompanied the release of the unofficial rule, this definition is intended to ensure that only objectively serious behavior that, if left unaddressed by the school, would jeopardize a student's access to education is actionable under Title IX. So again, a school could, even if you had sexual misconduct that didn't satisfy this definition, elect under its own policy or under a state definition, for example, to still proceed with some sort of conduct or proceeding, investigation, et cetera, but it wouldn't be actionable and covered under Title IX. All right, 3 other definitions. Complainant would mean the individual who has reported being a victim or on whose behalf the Title IX coordinator has filed a formal complaint. Now, the department notes that to be a complainant, the individual must have reported to the Title IX coordinator or an official with the authority to take corrective action. This ties to the definition of actual knowledge. If under the definition of actual knowledge, and we'll get to this in a little more detail in a minute, but the short of it is, if the alleged misconduct hasn't been reported to a Title IX coordinator or an official with the authority to take corrective action, then it doesn't trigger a Title IX obligation, which means at least for Title IX purposes in this framework, the person would not yet be a complainant. So that's why that's tied in that way. Respondent would mean what I think in most policies it already means, the individual who's been reported to be the perpetrator. And then formal complaint, and this is a really important concept throughout this proposed rule. Formal complaint means a document, so it's got to be in writing, physical document, signed by a complainant or by the Title IX coordinator, alleging the respondent engaged in covered conduct, and we'll talk about that in a second, and requesting initiation of the school's grievance procedures. So to be a formal complaint under this framework for Title IX, there's quite a bit that has to be in place. It's got to be written, it's got to be signed, it's got to request the school grievance procedures, and it has to be clearly allege covered conduct. That's a lot, right? So when do you have to respond as an institution under this proposal? First, an institution would have an obligation to respond to any report of sexual harassment when the school has actual knowledge of the alleged sexual harassment. The alleged sexual harassment occurred within an educational program or activity offered by the school, and the alleged sexual harassment was against a person located in the United States. So we're going to unpack all 3 of these. Okay. Actual knowledge. Remember, we're talking about this is one of those 6 new definitions. A school would have actual knowledge of alleged sexual harassment if notice is given, again, and we just talked about this a little, to the Title IX coordinator or any official with the authority to take corrective action. Once again, this is tied to those cases, the Supreme Court cases from 98 and 99, where they talked about what would constitute actual knowledge and trigger an actionable claim under Title IX. It's important to think about this for a minute. So what the department is saying is that it happened on campus or under a school's control, or that the school should have known, none of that would necessarily constitute actual knowledge, right? So the mere fact that it happened in an area over which the school has control, the mere fact that the school should have known better, or if it had been doing some level of diligence, would have known, that's sort of this constructive knowledge concept that you hear thrown around sometimes. None of that constitutes actual knowledge, right? The mere ability or obligation to report sexual harassment also, importantly, would not qualify an employee as one with authority to take corrective action. And where the Supreme Court previously got into this, they sort of talked about, for example, there could be people who are authority figures on campus, and someone might make a report to them, but they still might not have that ability to take corrective action, right? And they indicate that that's got to be a fact-based, case-by-case analysis as to whether or not someone is in fact an authority or a person with the authority to take corrective action on your campus. I listened in last week. National Association of College and University Attorneys did a very nice sort of briefing right after the unofficial rule was published. And one of the things they pointed out is, schools here may, in this instance, want to think about who those folks are and even go so far as to sort of officially designate who the people on their campus are who they believe could take corrective action, just to sort of keep track of that. But the important takeaway here is the school only has actual knowledge if the alleged sexual harassment is actually reported to the Title IX coordinator or one of those officials with the authority to take corrective action. Otherwise, there is no actual knowledge, and in that case, you remember from the prior slide, there would be no obligation to act, right? So you've got to have actual knowledge. Now, let me take another step back and just say again, an obligation to act under these rules and under Title IX, right? You could still, under your policy, require that folks act without regard to whether they reported to someone with the authority to take corrective action, for example. So, and the department says this several times in the commentary, and I don't want people to be confused and think that, what the Department of Education is forbidding you from acting here. What they're saying is for purposes of Title IX action and compliance, this is what would be required for it to become actionable and for you, a school, to be obligated. So the first piece is the actual knowledge. Second, it has to be covered conduct, right? So the sexual harassment must occur in the context or within a school program or activity. And here the department justifies this idea not only on the case law, but also, as the case law and the Supreme Court did, ties it back to the actual statutory language, right? But that having been said, this isn't like a geographical analysis. It's also a case-by-case analysis. And the department notes, schools are going to have to look at factors such as whether the harassment occurred at a location or under circumstances where they own the premises, whether they exercised oversight, supervision, or discipline over the location or its participants, or funded, sponsored, or promoted, or endorsed, or circumstance where the harassment occurred. So there could be a lot of room still for conduct that occurred off your campus at a location, at a fraternity house, at a study abroad location, something like that, to be deemed part of or having occurred within a school program or activity. The final component is the department notes that it has to have occurred against someone in the United States. The idea here is the Supreme Court has noted that if Congress doesn't specify that laws of the United States apply to folks who are outside of the United States, then agencies and courts can't assume or assert that they do. I mean, that's sort of the general idea, right? And the department here is essentially acknowledging that. But they also acknowledge, and they say, to be very clear, that individuals experience sexual harassment while out of the country, for example, at a study abroad location of your institution, or while they're on study abroad at another institution, but in your program or activity, for example, they would not be covered. That having been said, you could still cover those with your policy. Once again, even though they wouldn't be actionable under Title IX, your policy could still say, look, if this occurs, even if it's, while someone's at a location outside the United States, we will still exercise oversight and still would take that complaint and put it through our own process. It would appear that sexual harassment perpetrated online against an individual in the United States could be covered even if the perpetrator were located outside the country, right? If you go back through all of these, I mean, if you have actual knowledge, a person sitting inside the United States, and it's covered conduct, then it could be covered even, again, if the perpetrator is physically outside the United States when it happens. The department doesn't get into the online piece, and that may be somewhere where the schools listening in today who have significant online programming, you may want to ask the department some questions, and that's the kind of thing you can pose in the commentary or suggest in the commentary, that the department should address with specificity, situations involving online education. Okay. So how do we judge the sufficiency of a school's response? We've talked about these new definitions. We've talked about determining when an institution has an obligation to respond or to act. How is the department, or how do they propose that they would determine whether or not your response was sufficient? So the proposed rule would create a new standard for administrative Title IX purposes, but it is a standard, again, pulled out of those Supreme Court cases, for evaluating whether an institution's response to a report of sexual harassment is sufficient under Title IX. Specifically, under the proposed standard, if a school is obligated to respond, it must do so in a manner that is not deliberately indifferent. Okay, so what does that mean? The proposed rule includes some examples to try to sort of flesh out this idea. So, for example, a school would not be deliberately indifferent if, in the absence of a formal complaint, so you don't have anything in writing, but you've had sexual harassment that's been reported, there's just been no signed document requesting that you initiate an investigation, et cetera, okay? A school would not be deliberately different in that case if it offers and implements supportive measures. Here the department in the proposed rule is not, instead of using interim measures and accommodations, they're using the supportive measures concept. I believe that they think that that terminology or phraseology is sounds a little more neutral between the complainant and the respondent, right? At the time the supportive measures are offered, the school has to inform the complainant in writing of their right to file a formal complaint. So let me cover that again. So this is sort of a safe harbor, right? The department's saying, look, if you don't have a formal complaint and you offer and implement supportive measures, right, then no one's going to say we can't conclude that you were deliberately indifferent. It's sort of a safe harbor. But you have to make sure that you have made it clear to the complainant that they have the opportunity to file a formal complaint, right, to be or to qualify under that safe harbor. Similarly, a school would not be deliberately indifferent if when it receives a formal complaint, it follows all the proposed grievance procedures that have been proposed by the department. And that's sensible, right? The department says, this is how you have to do everything. And if you do it all that way, well, you can't be deemed deliberately indifferent. A school would not be considered deliberately indifferent solely because it determined it was not obligated to respond to a report of sexual harassment, and the department concludes otherwise. So really, and the department fleshes this a little bit out a little bit more in the commentary. But what they're saying is, look, if you go through the investigative process or you look into this and you make a determination that sexual harassment or this misconduct didn't occur, and then we come in and we take a look at it and we think, based on what our review, that it did occur, we're not going to say that you were deliberately indifferent just because when you review the evidence you came to a different conclusion, right? They said our role is not to come in and review all of this de novo and essentially decide whether or not your decision was a reasonable decision or not. Now, there could be other reasons that you might be determined deliberately indifferent, but what they're saying is you wouldn't be considered deliberately indifferent solely because we would come out in a different place after we evaluated the information and we would have decided to go a different direction. A school would be deliberately indifferent if it has actual knowledge. Remember, that means it was reported to the Title IX coordinator or someone with the authority to take corrective action. A school would be deliberately indifferent if it has actual knowledge regarding reports by multiple complainants of conduct by the same respondent, and the Title IX coordinator did not file a formal complaint. So for the Title IX coordinators on the phone, this clearly is placing an obligation on you. Now, it's not one that doesn't, or I should say it is one that more or less already exists. I mean, under the prior administration, it was made clear that the Title IX coordinators, one of your core responsibilities is to track reports of sexual misconduct and look for trends and things of that nature, right? So presumably you would be aware if you are seeing multiple reports of sexual harassment by one respondent or involving a single respondent. But what this is sort of going another step is saying, look, if that happens and you don't file a formal complaint, you, the Title IX coordinator, on behalf of those individuals, a school could be deemed deliberately indifferent. A school would be deliberately indifferent if its response to sexual harassment is clearly unreasonable in light of the known circumstances. Clearly unreasonable in light of the known circumstances. This sort of appears to shift the burden of reasonability from what we previously considered it to be, which was sort of having to establish that your response was reasonable. I will talk about this a little more in a little bit, though. I want to come back to it. Because I think as a practical matter, it's probably not going to, there is a legal implication here. I don't know that operationally it's going to change anything for schools, but we'll revisit it a little later in the presentation. All right, so interim and supportive measures. Emergency removal and administrative leave. As has been widely reported in the press and as is evident throughout this presentation and from a lot of the things that this administration has been communicating, part of their objective here is to create a process, whether you agree with this, whether you think they've accomplished it or not, I'll set that to the side. But part of their stated objective is to try to create a process that is fair and balanced between the complainant and the respondent. And you'll see, and this is a good example of their efforts to do that. So an institution would, under these rules, still be permitted to remove a respondent from campus on an emergency basis. But what this administration would require is that the school undertake an individualized safety and risk analysis. After you remove them, you can do that, provided that you undertake that individualized safety and risk analysis, determine that an immediate threat to the health or safety of students or employees justifies the removal, and provide the respondent with notice and an opportunity to challenge the decision immediately following the removal. right? So the first two pieces, I think I might have misspoke a little bit, or at least I don't want it to sound like that. To be clear, it looks to me like these first elements would have to occur before you actually remove the person. So you've got to do this safety and risk analysis. You've got to come to a conclusion that the immediate threat to the health and safety of students justifies the removal. Then you provide them with notice and an opportunity to challenge the decision immediately after you remove them. But you have to do all three of those things if you're going to pull somebody off campus. Schools also would be permitted to place a non-student employee, so basically an employee who's not also a student, on administrative leave. And the department has indicated they view this as consistent with Title VII Civil Rights Act and how schools and other employers are allowed to treat employees in such situations. Supportive measures. So the department has offered up this new definition of supportive measures, which you can see they're sort of going out of their way to make sure that this concept doesn't, even in the way that it's defined, isn't biased against respondents. So they say supportive measures would be defined as non-disciplinary, non-punitive, individualized services offered as appropriate, as reasonably available, and without fee or charge to the complainant or the respondent, before or after the filing of a formal complaint, or where no formal complaint has been filed. So it's a pretty broad concept, right? And it should be. Under the proposed rule, such measures should restore or preserve access to the education program or activity, avoid unreasonably burdening the other party. So there you see there's sort of, again, this idea, this implication that maybe in the past many of these have burdened the other party, protect the safety of all parties, and deter sexual harassment. And the department notes that schools have to maintain privacy of supportive measures to the extent that it would not impair the provision of the supportive measures. Now, the department actually, I believe they use the language confidentiality. I don't know about everyone on the phone. I mean, I draw a distinction between confidentiality, which is legal confidentiality that can be offered by, say, a professional counselor, and privacy, which is like confidentiality but acknowledges that the individual may not actually be able to maintain something as private if it was subpoenaed or there was a court order, right? So the department uses the word confidentiality. I've replaced it with privacy. They're not defining confidentiality in the context of this rule. So you have to maintain privacy of the supportive measures to the extent that it would not impair the provision of the supportive measures. And they make clear that the Title IX coordinator is responsible for, quote, coordinating the effective implementation of all of this. And I think most of us already think of it as working that way. There are also some examples of supportive measures that are offered. Counseling. This is all stuff I think we've seen before, but it's good that it's in the rule. You could, by the way, when you comment, suggest the department expand or revise this list. That's always something. It's not an exhaustive list. It's just an exemplary. Counseling, extensions of deadlines, modifications of work class or schedules, campus escort services, mutual restrictions on contact between the parties, changes in work or housing locations, leaves of absence, increased security and monitoring of certain areas of the campus. Now, I don't see in the rule, and I didn't catch in the commentary, whether this mutual is really loaded, and if there's some sort of suggestion that if you place restrictions, they have to be mutual. Again, the list is exemplary, not exhaustive, which means that theoretically non-mutual restrictions could also be on the list, right? But this is another area where schools may want to ask for a little more clarity around what the department is thinking. You know, I don't know if this was just a throwaway word or phrasing, I should say, or if it's, again, there's really, it's sort of loaded. All right, so grievance procedures for formal complaints of sexual harassment. Why do I have formal in yellow or gold, depending on how you think of it? Because if it's informal, meaning, again, remember a formal complaint, remember what it has to happen. It has to be in writing, signed. The person has to allege conduct that's covered conduct, and they have to request that you initiate the grievance procedures. If you don't have a formal complaint, these grievance procedures are not activated. You know, we've talked earlier about what the department would propose is sort of the obligation to respond in the case of an informal complaint, and what would be considered a safe harbor. In other words, you know, sort of what the sufficiency of the response would have to be if you're responding to an informal complaint. If you have a formal complaint, and again, somebody comes, it's an informal complaint. One of the other things, remember, is you're obligated to provide them obviously resources, but also to let them know what their options are to file a formal complaint. Okay, if they do, then the Title IX proceeding is subject to these grievance procedures, or rather, you have to have grievance procedures to investigate and resolve the issue that comply with these proposed rules. Again, I like to see visuals. I kind of like the blueprint approach. So there are 7 components to the grievance procedure framework. We're going to walk through all these. You got some basic requirements, and then the department talks about what the notice of allegations needs to look like and ongoing notice requirements. They get into the investigation, determination, a lot around that. Appeals, informal resolution, and record keeping. Okay, basic requirements. You have to treat complainants and respondents equitably. No problem. Require an objective evaluation of all evidence. And some of these are, almost like goals, right? Require that coordinators, investigators, and adjudicators be trained and free of conflict of interest. So you've got significant training requirements here. Include a presumption of innocence for the respondent. So you have to include in your policy, and this is in a couple of places in the proposed rule, you actually have to include a statement that says respondents are essentially, presumed innocent until proven guilty. Theoretically, that's how we have all operated, but I think that there are concerns around how respondents have been treated in the department and its efforts, again, to sort of create a more balanced framework, at least in their mind, is asking schools to include this clear statement. Include reasonably prompt timeframes for resolution. So the 60 days from the Obama era it doesn't show up in these proposed rules, but there is an expectation that things will move along promptly and that delays would only be for good cause. Describe the range of sanctions and remedies. Describe standard of evidence. All of this you would expect to be in your sexual misconduct or grievance policy. Describe appeal processes and standards if offered. So notably, this rule the department has not proposed that you have to provide an appeal, right? You may have to provide some sort of appeal under your existing employee policies. There may be state laws, like, for example, in New York, where an appeal is required. But for Title IX purposes here, the department is not requiring that you make an appeal available. Describe range of available supportive measures. Most of this, again, I expect already is in most institutions, sexual misconduct, annual security report, sort of combination of policies. So what do you have to include in the notice? Upon the receipt of that formal complaint, so it's in writing, it's been handed, satisfies the requirements, it's a formal complaint. Schools would be required to provide notice to known parties, so that would be complainant, respondent. You could have presumably multiple complainants or respondents, but to the known parties, that includes the grievance procedures, so your whole package, sufficient details of the allegations that constitute a potential violation of school policy. The department unpacks in the pros rule, I don't include it all here, but they have some language around what would constitute sufficient details, and it's robust, right? You got to be specific about the allegations, date, time, place, that kind of thing. Statement that the respondent is innocent until proven guilty. Again, so that's got to be in the notice clearly, although per the prior slide, it also has to be in your grievance procedures. So if you're just handing them a copy of your grievance procedures, they'll already have that statement. And rights regarding review and inspection of evidence. And there are some fairly involved rights around review and inspection of evidence, and we'll get to that in a minute. Ongoing notice requirements. So schools are also required to provide notice if the school decides to investigate additional allegations. And this is sort of fundamental to the idea of due process, but organizations miss this all the time, and it's something that attorney types like me will tee off on if you're trying to challenge a process and whether it's been carried out correctly. And that is, if in the course of an investigation, new allegations come to light that the respondent's going to have to potentially respond to and going to be held accountable for, you have to notify the respondent of the new allegations, right? Otherwise, you tell them, you violated these 3 things. You get to the hearing. They're prepared to respond to those 3 things. And all of a sudden, the adjudicator says, well, I've got 5 things listed here. And what that means is the respondent has not had notice of the additional 2 allegations. So what the department is saying here, and this is just good practice for schools in general, even outside of sexual misconduct proceedings, in your regular disciplinary proceedings, whatever notice you give to someone, it should include all of the allegations that they're being expected to defend. And if new allegations come forth in the course of an investigation or proceeding, you need to make sure they get notice of those additional allegations. The other thing the department requires is notice to the invited or expected parties, so anyone who is invited or you expect to show up, of the date, time, location, participants, and purpose of any hearings, investigative reviews, or other meetings with sufficient time for preparation. So they don't detail what that is, but just be mindful if you're sending someone a notice the day before, you may not get the job done. And I can tell you, if you have a situation like that, a respondent ends up, there's a determination that they violated policy, they get kicked out of school, and you get sued, you can bet if you only gave the respondent a day to review the notice, that's going to come up. The attorney's going to raise that issue. So what about investigations? Now we're in the heart of it, right? The investigations and the hearing. When to investigate. So schools would be required to investigate allegations of any formal complaint. Schools would be required to dismiss the formal complaint if the alleged conduct would not constitute sexual harassment as defined in the regulation, even if the conduct were proved and all the parties agreed that whatever is alleged happened, if it doesn't satisfy that definition of sexual harassment, or if it did not occur within the school's program or activity. So I think this is problematic, this required to dismiss language, and I would encourage schools to think about this, and if you agree with me, to potentially comment. So, I noted earlier, the department has repeatedly said schools can use a broader definition of sexual harassment, right, sexual misconduct. You may have a state that requires that you use a broader or different definition, and you have the opportunity, even if it's not actionable under Title IX, you have the opportunity to continue to move through your conduct process, right? The department has indicated that this dismissal language was put in to, quote, ensure that a school's resources are directed appropriately at handling complaints of sexual harassment, and that's a little grammatical error on my part, and that only conduct covered by Title IX is treated as a Title IX issue in a school's grievance process. So the department emphasizes in the commentary, and what I just said, that schools remain free to respond to conduct that does not meet the Title IX definition of sexual harassment or that did not occur within the recipient's program or activity, including by responding with supportive measures for the affected student or investigating the allegations through their student code of conduct. But such decisions are left to the recipient's discretion in situations that don't involve conduct falling under Title IX. Here is my problem. As a practical matter, if I've initiated an investigation and I'm working through that investigation, someone's filed a formal complaint, right? And then there's a determination is made. Let's go back to this prior slide. Let's say that there's a determination that's made that the sexual misconduct didn't occur within our program or activity, So now I'm mid-investigation. I've given notice. We still want to proceed. And we think, well, okay, but under our policy, or under some state law or otherwise, we still want to move forward. I've got this language that says we're required to dismiss the formal complaint. Well, how do you carry that out or document that you've, quote, dismissed the formal complaint while still proceeding with the formal complaint, even if not in the Title IX context? Surely it can't be that the department expects that you would somehow communicate to the parties, well, we've got a Title IX proceeding and we've got a non-Title IX proceeding that's identical to the Title IX proceeding, and so we're dismissing the Title IX proceeding, but we're still going forward under the non-Title. I think this is very confusing. I think it's problematic for schools. It seems it would be much easier for the department to just say, if the sexual misconduct doesn't satisfy these requirements, if it's not sexual harassment or it's not within the school's program or activity, then it's not actionable under Title IX, but the school is free to proceed under its conduct policy. Or just say something like that, and it would sort of resolve that tension. I think the way that it's written is problematic. I also, for that matter, think that something along the lines of this statement that's in the commentary, in my view, it would be very helpful if it were in the rule. Wouldn't it be great if the department just included an explicit statement that schools are free to respond to conduct even if they're outside of Title IX, right? And put that in the rule itself. So, it's up to you all to decide whether you want to do that, but I think that would be a good place to seek some clarity. General investigation requirements. Institution's investigation process would be required to ensure burden of proof, and the burden of gathering evidence rests on the school and not the parties. So it's your obligation as an institution to carry out your responsibilities under Title IX, to investigate and try to pull together all the evidence that's necessary to reach an appropriate determination, right? The burden is not on the complainant or the respondent. You got to provide equal opportunity for the parties to present witnesses and evidence, and you can't restrict the parties' ability to discuss the allegations or to gather and present relevant evidence. And I think the first part of that's hard because you're working so hard to maintain privacy. And of course, you've got FERPA and ostensibly HIPAA and all these other things that come into play, privacy regulations. But, you can't put a gag order on the parties. The department says, if the complainant or the respondent wants to go to the press or speak about things, they can do that. We can't stop them from doing that as an institution. Advisors in general. Schools would be required to afford the parties equal opportunity to have advisors. You don't have to permit to limit the choice of advisor or the advisor's presence. So let me restate that. Schools cannot limit, would not be permitted under the rule to limit the choice of the advisor or the advisor's presence. So you can't tell a student you can or can't have a particular advisor or an employee, and you can't tell them you can't have your advisor at this meeting or not that meeting. But you can restrict the extent to which advisors may participate in the proceedings. You know, the other thing is, if I believe under this rule, and, you know, check with your counsel, but it looks to me at least like you also ostensibly could forbid advisors entirely, right? Because the primary rule here is you have to afford the parties equal opportunity to have advisors. So if you say, you know, no advisors present at any meeting, you would think that would work, although we're going to talk in a minute about why that also could become problematic. Access to evidence. So you have to afford both parties equal opportunity to review and inspect any evidence that, one, was obtained as part of the investigation and is directly related to the allegations raised in a formal complaint, even if the school does not intend to rely on that evidence in reaching a determination. I'm calling this, just for purposes of this presentation, reviewable evidence, right? So if you've got reviewable evidence, you have to allow folks the opportunity to review and inspect it. There are two timing standards on access to this reviewable evidence. Prior to the conclusion of the investigation, and early enough that each party can meaningfully respond, you have to provide them access to the reviewable evidence. Also, prior to completion of the investigative report, schools have to send reviewable evidence to each party in an electronic format and give parties at least 10 days to submit a written response, which the investigator has to consider. My take is if you're complying with bullet number 2, you probably are complying with bullet number 1. I think these are a little confusing. I think this is also a good area for comment. The other thing I'll note is that the department has specifically requested comment around this technology idea. For a large university system or university school, it may not be so hard to satisfy some of these technological requirements, but for very small schools it might be, and this may be another area where you want to comment on sort of the burden of providing types of electronic access and things along these lines. You have to issue an investigative report. You have to create it. It's got to summarize fairly the relevant evidence. And at least 10 days prior to any hearing or time of determination, I'm doing my air quotes as I say that, schools will be required to provide an investigative report to parties for their review and written response. So going back, remember, you got to get evidence to them in advance of preparing the investigative report so they can look at it and comment on it. And then you actually have to make sure to provide them the investigative report before the hearing so they have plenty of time to review it and comment on it. Hearings. So there's some real bombshells here. Institutions of higher education would be required to provide a live hearing for formal complaints. I don't know if I have any elementary or secondary folks on the line. For the most part, there aren't that many distinctions. This is one place where there is a distinction. Elementary, secondary schools aren't subject to the live hearing requirement. But institutions of higher education, again, would be required to provide a live hearing if you've got a formal complaint, right? The adjudicator also cannot be the Title IX coordinator or the investigator. So these are both big changes. Right? These are big changes that are being proposed. Lots of schools do paper hearings. They may not have any hearing concept at all. And lots of schools have used the single investigator model, where you've got one person who does the investigation and serves as the fact finder and decider. Here the department, and by the way, one of the reasons I highlighted that Sixth Circuit case early in the presentation is because the department clearly is watching all these decisions, right? And this reflects in part what was decided by the Court of Appeals in the Sixth Circuit. The federal court in the Sixth Circuit, which is this idea that you need to have a neutral fact finder. Okay, reviewable evidence must be available at any hearing, including for purposes of cross-examination. So cross-examination is the next big topic. At the hearing, the adjudicator would be required to allow each party to cross-examine the other and any witnesses. And that cross-examination could include relevant questions and follow-up questions, including those challenging credibility of the witnesses. The rule proposes that cross-examination must be conducted by each party's advisor. So if you're required to have a live hearing and the cross-ex has to be provided and it has to be conducted by an advisor, it would not seem that you could restrict the parties from having advisors entirely. You can tell them, you know, you can prevent their advisors from participating at a certain level, but you got to let them choose their advisor. They're going to have an advisor, right, to do the cross-examination, and you have to treat the advisors equally for each side. If a party does not have an advisor present, the school must provide an advisor aligned with that party to conduct cross-examination. So this obviously is, in my mind, one of the most controversial provisions here, or problematic is probably a better word. I think if I'm a school, this is definitely something I want to comment on. First of all, a lot of smaller schools may not have resources. What if you can't find an advisor aligned with the respondent or the complainant, or you don't have anyone who's willing to serve in that role? If one party has an attorney as their advisor, does that mean that the school has to supply an attorney to be the advisor for the other party that doesn't have one? What's the cost involved in all of this? I think this is an area that's ripe for discussion. I expect there will be many, many comments, and that many of the big higher ed associations in D.C., ACE, NICU, those guys will be commenting on this at length. Certainly encourage you all to think about it. If a party or witness does not submit to cross-ex, the adjudicator is not permitted to rely on any statement of that party or witness in reaching a determination. So to be clear, if you've got a complainant that will not submit to cross-ex, then that means the adjudicator can't rely on any statement that that complainant made when reaching a determination. So what the department is really requiring here, they're saying, is everyone has to be available for cross-examination. I will tell you that is consistent. Obviously, there are going to be victims advocates and others who are strongly opposed to this. It is consistent with the Sixth Circuit decision and other, and this is what the department talks about, other decisions in the judiciary that talk about the fact that, cross-examination is so critical to due process. So I think this is going to be a topic of extremely passionate debate. With regard to cross-examination, the department also proposes, at the request of either party, school has to provide for cross-ex to occur with the parties located in separate rooms, so you don't require them to be in the same room together. The department is acknowledging that's a bad idea, or can be. But you have to provide technology that would enable the adjudicator and the parties to simultaneously see and hear the party answering the questions. So what you're imagining here is the complainant and the advisor for the respondent in one room, and the respondent and the adjudicator potentially in another room, or maybe the complainant's alone in a room and the other three are all in a different room, and technology is basically connecting everyone, but allowing them to be physically in different places. Not only is this sort of unclear how exactly this would work in certain circumstances, also you get this now technological burden. Again, I suspect that the large state universities of the world may already have facilities that could enable this. Miss Betty's Beauty College, that happens to get federal financial aid, probably does not, and there are going to be a lot of schools in between. And so this is another area where folks may want to comment on the burden of providing this type of facility. The adjudicator has to explain to the party's advisor, I'm on the second bullet, any decision to exclude cross-ex questions is not relevant. Again, the NACUA folks last week made a great point here, and that is, if you ever go to court and a judge decides to disallow a question on the basis that it's not relevant, the judge does not have to explain at any length their rationale. What's interesting here is the department's actually placing an obligation on the adjudicator to explain to the advisor any decision as to want to disallow a question on the basis of lack of relevance. It's also unclear whether the advisor would have any ability to object to that. So basically just tell them what you think and they're stuck with it. This is a little unclear to me as well. Exclude evidence of the complainant's sexual behavior or predisposition. So the cross-ex would have to exclude this unless the evidence is offered to prove that someone other than the respondent committed the alleged conduct, or the evidence concerns specific incidents of the complainant's sexual behavior with respect to the respondent and is offered to prove consent. So this is pretty consistent with current rape shield laws, this concept right here. By the way, I just want to highlight in the lower right-hand corner, I do have citations for you to the regulatory language, I think, throughout the whole presentation. All right, so moving on to determination. You have to have a written determination. It needs to be issued by your adjudicator, and it's got to include a number of things. Sections of the code of conduct allegedly violated. That's your, meaning the school's code of conduct or policy, et cetera. And a lot of times that may just be a reference to the prohibition on sexual harassment. A robust description of the procedural steps taken from complaint all the way down to determination. So this is significant, and the department includes additional detail around what it means by robust. But essentially, they expect you to have a pretty strong narrative that describes in a pretty high level of detail all the steps that were taken from when you first got that report all the way through to the determination and the issuance of this written document. findings of fact, conclusions regarding the application of school policy. It sounds a lot like something a judge would write or a lawyer. Results for each allegation, procedures and permissible bases for appeal. So there's a lot that has to go into these. For schools without a general counsel, this may be something that you want an outside counsel to help you out with, or at least someone with experience writing these kinds of things. Evidentiary standards. So this is one of the hot topics, right? Under the proposed rule, schools could apply either a preponderance of the evidence or clear and convincing. So the department's not requiring one or the other. Their rationale is, yes, in some civil procedures, preponderance of the evidence is used. On the other hand, in these types of processes, you don't have discovery, you don't have rules of evidence, you don't have some of the protections that are available in good old civil litigation, and so maybe that justifies a higher standard. They're going to allow schools to make it up or make the decision, but they do say if you use preponderance of the evidence, you have to use that standard for the conduct code violations that don't involve sexual harassment and carry a similar maximum disciplinary sanction, which presumably would be getting kicked out of school or termination from employment. You also have to apply the same standard of evidence for complaints against students and employees. Again, this is under the proposed rule. These are all proposed. Appeals. Schools would have the option of offering an appeal. I mentioned that earlier. If an appeal is offered, both parties have to be able to appeal. Complainants may appeal the sufficiency of remedies, but they can't demand specific sanctions. And this is straight out, again, of some of that Supreme Court law, where the department said, look, under Title IX, a school has a responsibility to try to free the school environment from sexual harassment, sex discrimination, right? So a complainant could say, look, the remedies you put in place aren't sufficient to achieve that goal. And that's an appropriate basis for an appeal. What the complainant can't say is, the remedies you came up with may be sufficient, but they're not the remedies I want, right? I want different specific sanctions. And really, what the court is saying is, if it is reasonable that the remedies and sanctions accomplish the purpose of eliminating that sex discrimination, that's the obligation of the school, not to respond to specific requests of the complainant. Institutions would have to ensure that they notify the other party in writing when an appeal is filed and implement appeal procedures equally for both parties. That the appeal decision maker is not the investigator or the adjudicator, so you got to have another set of people. By the way, I want to take a step back. I did not see anything in the proposed rule or in the commentary that suggested that your Title IX coordinator could not be the investigator. And if I missed that and somebody catches it, let me know. But what is very clear is that the investigator and the adjudicator cannot be the same person. Your adjudicator can be neither your investigator or your Title IX coordinator. Got to be somebody completely independent. And whoever's doing the appeal also has to be a different person, right? Both parties get a reasonable equal opportunity to submit a written statement. The school issues a written decision, and the school provides written decisions simultaneously of both parties. So pretty light around the appeal. Informal resolution. The department does recognize the ability of schools and permit schools to engage in an informal resolution process. Most of you have something like this in your policies already, provided you provide the parties with a notice that includes certain specific elements around the allegations, process, and consequences, and that both parties voluntarily consent to go through the informal resolution process. They don't say this, but you probably also want to make sure that both parties have the opportunity to cease participating in this process at any time, right? Record keeping. Institutions, this is another proposal, and this is another place where the department is specifically asking for feedback from schools. Institutions would be required to create, make available to the complainant and respondent, and maintain for a period of 3 years records of each sexual harassment investigation, including determination, sanctions, remedies, any appeal on the results, any informal resolutions, and materials used to train coordinators, investigators, and decision makers at the appeal level. What I thought was interesting was this seems to suggest that you potentially have to make your training materials available to complainants and respondents. I don't know if that's really the department's intention or it's just an oversight in the drafting. It seems odd to me that all of the documentation you use to train your various folks would be that you would have to make that available to a complainant and a respondent, but that is the way it reads right now. Institutions also would be required to create and maintain for a period of 3 years, but not make available to complainants and respondents, just keep and maintain, records of any actions, including any supportive measures, taken in response to a report or formal complaint of sexual harassment. So you have to document why the response was not clearly unreasonable and that it has taken remedial measures. it does not appear that these records have to be made available to the parties. I mentioned that. So there's a couple things I want to say. I mentioned earlier, I'd return to this idea of not clearly unreasonable as the standard. So first of all, anytime you say the phrase not clearly unreasonable, a lawyer gets its wings. I'll just tell you that. That was clearly written by a lawyer. You know, there is a legal distinction, is what I mentioned earlier. So if you have to establish, which has long been the standard, that something is reasonable, that means you've got to have enough evidence as a school to show that you get to that level, right? Here, you have to have enough evidence or be able to demonstrate that you were not clearly unreasonable. So you could have a response that is ostensibly unreasonable, right? I mean, there could be some question, but if your response was not clearly unreasonable, then you haven't hit the standard, right? That having been said, and I mentioned earlier, I doubt this is going to change what anybody does. At the end of the day, you're going to gather your evidence and documentation, try to make sure that you can show that you acted in the most reasonable and appropriate way possible. And whether or not you satisfied the applicable standard will come up down the line. Hopefully never, but if you end up in a situation where somebody's got a question, right? Updates to rights, responsibilities, and faith-based exemptions. So that's all the new stuff. I know we've got 5 minutes left in regulation here. I'll go quickly. This is the stuff that's already in the law that the department's revising, right? And they're trying to improve, or for whatever reason they're updating. The proposal will clarify that the department won't assess monetary damages for Title IV violations, which is already the case, right? The department doesn't typically assess monetary damages, but they could require a school to pay out some amount as part of equitable resolution, right? So they could say, and they give some examples in the commentary, if you, for some reason took scholarships away from a group of women athletes and not the men athletes, they could say, well, you've got to reinstate the scholarships, and of course that would be have a monetary consequence, but it's not monetary damages. It's an equitable remedy. And of course, the department retains the right to demand remedial compliance action or suspend or terminate institutions' participation in the federal financial aid programs. The proposed rule also has some clarifications around how this proposed rule relates to constitutional rights, FERPA, Title VII, some technical things like that. There are revisions to those core Title IV responsibilities that have been there a long time. Those are, you have to have a Title IX coordinator, you have to have a statement of non-discrimination on the basis of sex, et cetera. They would update that provision. You can see really clearly what those changes look like in the red line that we provided, but they would eliminate the inference that Title IX coordinators should conduct investigations, require email and coordinator contact information. Email, that's just a modernization of the requirement, right? Update notification, dissemination, and publication requirements for that statement of non-discrimination, require that grievance procedures conform to the new rules. Also, they clarify that the grievance procedures only apply to students and employees located in the U.S. Finally, the department also, and this may only be of a concern to a subgroup on the call, but for institutions that are faith-based, the statute says, and it's important to note this, I have a lot of faith-based clients, the statute says if there's some element of Title IX that conflicts with your religious tenets, then you're exempt from those elements of Title IX. The statutory language is not required that you go through some sort of exemption process. But in the rule, and as has long been the practice, institutions that felt they needed an exemption were required, or at least under the rule encouraged, to submit to the department an exemption request. They're taking that out. They're saying the proposed rule would dispense with that requirement. They have to seek acknowledgement of the Title IX exemption. Instead, if there's an action, a Title IX action, the institution would just have to raise the exemption at that point in time during the investigation, with or without regard to whether they previously submitted it to the department. Finally, I want to highlight again, you can comment on any aspect of this rule, but the department at the very end of the commentary has 9 specific areas they've asked for comments on. This is a great opportunity to give them feedback. I mean, they are open to feedback here and specifically soliciting it. Some of it has to do with the application of the rules to different types of parties, meaning elementary, secondary, minors, persons with disabilities. And then they also ask for comments around like training obligations, standard of evidence, and some of these technology requirements as well. So anytime an agency specifically solicits feedback, it's a good opportunity to let your voice be heard. Finally, I'll just note that we have have a blog. We write all the time. It's free and would love for you to stop by. We also, all the webinars like the one we do today, I mentioned earlier, are free and on demand. They're on our website. So within about an hour, this one ought to be up. That's me doing my best impression of Guy auditioning for stage production of Dead Poet Society. And with that, I'll go down to Q&A and we'll see if we've got any questions that we can try to get to. All right. Let's see here. Okay, regarding appointing an advisor aligned with interest of party if the party does not have one. If the opposing party has an attorney for advisor, must the school appoint an attorney? That's a great question, and that I blew through it pretty quickly there, but it's unclear. So the department doesn't, I did not see anything in the commentary, and there definitely is nothing in the proposed rule that indicates whether or not, again, if the other party shows up with an attorney, let's say the complainant has an attorney and the respondent does not, the school has this obligation under the proposed rule to provide, quote, an advisor aligned with the respondent's interests. But if the complainant has an attorney, does that mean that the school has to come up with an attorney or counsel to represent them so that they're sort of equally represented, at least insofar as attorneys would be, sort of equally matched? Unclear. Great question. Definitely an area where schools and trade associations and others should be pushing for clarification. All right. Do you agree that the effective date of the final rules should be at the beginning of an academic year, like say August 15th? If so, would you encourage listeners to include that point in any comments? Lots of schools don't operate on the traditional academic year. You've got lots of online programs that have rolling enrollment. You've got lots of institutions that have folks on campus throughout the summer, employees that are employed year-round. So I'm not sure that the department would be persuaded by the notion that the rules should be delayed to become effective at the beginning of what for no doubt for most institutions is when most of your students are showing up. But keep in mind, this applies to all your employees too, right? My guess is the department's going to want to make this effective as soon as it can get it done. Look, the second part of this question is, do we think it's worth making the point in comments? I think anything like that is worth making in comments. I mean, if you've got meaningful feedback for the department and you have a reason why you think that, something should be done one way or another, you ought to bring it up. There may be other schools or associations that agree with you, or it may be something that no one else has realized that makes a lot of sense. So I encourage folks, again, it's free to file comments. It's really easy to do. I encourage folks, just remember they're public, but I encourage them to put in if you have a concern or think something can be improved. Let's see. Can you expand on the intersection of VAWA, that's Violence Against Women Authorization Act 2013, and the proposed rules? So these rules are intended. VAWA from 2013 amended the CLE Act, right? And subsequently, the department put out new CLE Act regulations implementing the CLE Act that reflected those changes. And that's where we got a lot of the additional content around training obligations, around stalking and domestic violence and some of these other concepts, right? There are a lot of changes at that point in time. And I think that where the intersection is, you'll see in the commentary that the department is making an effort throughout these proposed rules to ensure that they generally accord with CLE Act obligations. So there is an intersection insofar as, the department is looking at the CLE Act, they're looking at the obligations under the CLE Act and the regulations that relate to the CLE Act, and they're trying to make sure that those marry together and don't create, and there's not tension. That having been said, I don't see the department specifically looking at VAWA so much, again, as sort of looking at the CLE Act, understanding that the CLE Act and its regulations implement those VAWA changes and reflect those VAWA changes. And so there is a recognition and an effort to make sure that they all work together. But these implementing regulations really are about carrying out the Title IX statute. And so that's what they're focused on, which is why you're not going to see a lot of references or ties specifically to VAWA. Great question. Let's see. Does quid pro quo discrimination apply to employees only? No, definitely not. So quid pro quo discrimination, if you have Well, let me make sure I understand the question. So you could have quid pro quo discrimination that occurred between two employees. So you had a supervisor or a senior administrator who was engaged in quid pro quo with a junior administrator or employee, right? Anyone who's in a senior position. That's how it works. But you could also have a situation where an employee or faculty member, staff member, et cetera, is in a quid pro quo situation with a student, because I think any employee would generally be considered in an authority position vis-a-vis a student. I mean, you could look at the specific facts and circumstances, and I suppose you could argue that that's not the case. But I think the department in its definition is really envisioning employees and students in that relationship. But I have no doubt that certainly under Title VII of the Civil Rights Act, but also here, I believe that sex discrimination, quid pro quo between two employees, a supervisor and a report, would also be considered sexual harassment covered by Title IX. Let's see. What do the new rules mean for cases involving employee respondents? Does this mean that when we have a student bringing forth a quid pro quo allegation against faculty, for example, that we have to provide the cross-examination opportunity where the faculty's advisor can cross-examine the student? We're concerned that this will regularly see imbalances where the employee will have legal counsel and the student might not. I think that is exactly what this means, by the way. I mean, I think the department would say, look, cross-examination is a fundamental component of due process. And if the claimant is a student or an employee, it doesn't matter. At the end of the day, the idea is that the respondent who's been accused has to have the opportunity to cross-examine the accuser, and that's fundamental to the process. But one of the areas that the department here specifically asked for feedback is on the application of these rules to employees. So, for any reason, but certainly for this reason, for example, I think you could comment and raise that issue. And again, they're specifically soliciting feedback on, how this applies to that employee-student or employee-employee relationship. Let's see. Aaron, please help us understand deliberately indifferent. Well, I think this came in right before I had those additional slides where we talked about sort of the would and would nots. But if you go back in the deck, you'll see those examples. There are, I think, 1, 2, 3, 4, 5 different examples of what would constitute deliberately indifferent. Is a hearing over the phone a live hearing? That is an interesting question. I am under the impression that it probably would not qualify, and here's why. If you look in some of the some of the jurisprudence out there, and I think maybe it's even in the commentary, there's an acknowledgement that part of the great value of cross-examination is the ability of the adjudicator to visually see how the person being cross-examined reacts. And that can inform, for the adjudicator, inform the credibility of that witness. If you're doing the cross-examination entirely over the phone, then it creates a situation where the adjudicator and the other party, the other side, can't see the body language of the person who's responding. The other practical issue is, you could have an advisor on the other side coaching someone, they could put it on mute, whatever, and there could be problems along those lines. Whereas if, you've got this visual technology where you're doing it in real time, and you can see the other person, it makes it much harder for them to put you on mute and ask their attorney what they ought to say, for example. So my guess is that the department probably would not go for that. But again, great comment and a great question. What I do think is that there's a lot of room for questions around what kind of technology or live setup is required if you're not putting people in the same room together, especially if you're a school with limited resources. Let's see. Okay. We have a lot of questions. Do the regulations preclude students from seeking justice outside the Title IX grievance process? Certainly not. Certainly not. So, of course, a student can always go to court. I mean, they can, if they believe they've been subject to criminal conduct, they can go to the law enforcement, right, for assistance, and local law enforcement. The state can prosecute. They can file a civil lawsuit at any point in time if they believe that they have grounds to do that. Right? They could seek redress under the institution's Title IX grievance process, and if the institution has, either because it's required to or voluntarily, a process that would still capture sexual misconduct that still does not satisfy this definition, proposed definition of sexual harassment, then the student could say, well, then the complainant could, want to continue with the grievance process and moving through that process to the extent that that option was available. So I think there would be opportunity there. Nothing in this law, these proposed rules, would attempt to limit the legal, redress that a student, claimant or respondent, would have in court, their ability to get access to the courts. Could an adjudicator be an individual, or does it need to be a hearing board? Great question. So I did not see anything in the proposed rule or in the commentary that suggested that you would have to have an appeal panel. Oh, well, let me back up, because you're asking about adjudicator. An adjudication panel in the initial process, or for that matter, at the appeal level, if you allow an appeal, a panel, right? My impression was it could be an individual who serves as your adjudicator. They just can't be the person who's the investigator or the Title IX coordinator. Now, if you go to an appeal, again, I didn't see anything here that required a panel, but I do know, for example, again, I mentioned I was just dealing with New York state law. New York requires a panel if you go to an appeal. So setting aside these proposed rules, you may still have to offer an appeal or, for example, have a panel or multiple parties as decision makers under a state law. And that's why you want to make sure that you're keeping an eye on, the sort of the whole framework and where some of these other requirements that may be out there. Let's see. I can see how these rules will be more problematic for K through 12. Will you be doing a webinar in K through 12? So apologies. I do some work with K through 12, but I'm primarily a higher education guy. We'll probably not do a separate webinar for K-12. That's a great request, and my hope is that someone out there will. I will say, though, there are very few places, very few, where the application differs. Right? One of the only ones is in that institutions of higher education have to offer the live hearing, and K through 12 does not. And if you go read, all of that is captured in 2 paragraphs of the proposed rule, and you can see that in the composite or in the comparison document that we included. Let's see. I'm also hearing somebody, if folks aren't on mute and you could put yourself on mute, that'd be great. Let's see. In addressing quid pro quo harassment that occurs off campus, would the university have jurisdiction to address the behavior? Well, it'll depend, right? So it could occur in the context of, remember, you have to have actual notice. It has to be sexual harassment, right, first of all. And then you have to have actual notice of it, and it has to occur within a program or activity that you're offering and to a person in the United States. So let's say it's off campus. It is quid pro quo in the definition of sexual harassment, and you've got actual notice. So then I guess the question becomes, did it happen within an education program or activity? And, one of the things we talked about and the department emphasizes in the commentary is that analysis is really independent of physical location, right? Because you could have an away game where something happens, right? It could happen at a fraternity or sorority house off campus that you still control and have oversight over, maybe even own, right? So it doesn't have to be on campus. It could be off campus. If it satisfies those other elements, it appears to me that it would be actionable under Title IX, and the institution would have an obligation to respond. Let's see. Do cross-examination questions get submitted in advance or during the live hearing? The department doesn't go into any detail. My expectation is that, I think that institutions, I guess, could offer some sort of opportunity or variation where there would be some advanced cross-examination. But I really think that the reason they stress a, quote, live hearing is because advisors should have the opportunity to ask questions live. Right? And so if you require folks to submit cross-examination questions in advance, you deprive them of that opportunity. Or if you require them exclusively, if you only afford them, solely the opportunity to supply the questions in advance, I should say, then you deprive them the opportunity to ask them in a live setting. And I think, again, part of the idea here, this core concept, of cross-exam, is that you've got an opportunity to see how people react on the fly, right? That's really what it's about. So I think if you limited it to advanced questions, it would probably be problematic. But again, I did not see anything where the department addressed that specifically. Could the school only use technology for the hearings and have all parties in different geographic locations? Yeah, I do get the impression that the school could use technology for all of the hearings as long as they can facilitate that live hearing, and that the parties would never necessarily need to be in the same geographic location. Are independent contracts and adjuncts still protected under proposed regs if they have been subject to sex discrimination by a student or coworker? Yeah, that's interesting. I mean, I think that they would be. I mean, they're still employees, and I'm not sure. I'd have to go back. I haven't thought about it a lot. I mean, I have to go back and see if there's something in the commentary or somehow where the department is excluding, you know, an independent contractor or an adjunct from the definition of employee. But the idea is that Title IX covers both students and employees, right? And so if you've got an independent contractor or an adjunct, but, you know, under, and, you know, there's an analysis, and I'm not an HR attorney, but I know anytime you do labor law, there's sort of an analysis as to whether or not somebody is or is not an employee. And, you know, we'll try to include things in these independent contractor contracts that try to suggest that they're not an employee, et cetera. But, you know, I think I mean, maybe it would go to that question. But if they're an employee and there were a determination that they were an employee, I think they would be covered. And I will tell you, my gut and my read on this is that they would be. I don't think the idea is that all your adjunct faculty are going to be excluded from coverage by Title IX. I find it very hard to believe that the department would embrace that kind of interpretation. How do these amendments square with the longstanding legal concept that student disciplinary proceedings are subject to minimum due process protections and not full-blown trial-type processes? Well, particularly a private nonprofit, right? Or I'll just say non-public institution. Public institutions, you know, you have to provide 14th Amendment due process. But private nonprofit institutions, or proprietary, whatever, but, you know, non-public institutions, there's that question about, are you really supposed to be subject to due process, or is it just sort of basic fairness? I mean, I think what these rules say is, you know, Title IX is enacted under spending authority of Congress. It's sort of like a contractual arrangement, and the Supreme Court has acknowledged that. So it's not so much that there's this independent obligation or right to due process. What the Department of Education is basically saying is, you know what, you may have some independent obligation to provide basic fairness or due process under, you know, a federal or state constitution or something along those lines. But in this case, you're taking our money, and if you're going to take our money, you can't discriminate on the basis of sex, and if you get these kind of reports, you got to manage them this way. That's it. It's, you know, if you take their money, you're on the hook. It's under the spending clause. And so what they're creating these obligations because you're taking federal funds, right? Not because not to reflect or somehow capture an independent due process right that exists. And outside of this, you're right. I mean, historically and in courts, I mean, the consideration around whether due process or basic fairness was required really was more of a sort of fundamental rights constitutional type question. Can quid pro quo be applied to student versus student situation? I'm not sure. Unless, you know, I mean, what's interesting is, like, what if you're the president of a fraternity, right? And you've got someone who wants to rush the fraternity. And you say, you know what, I'll let you into the fraternity if you do X, Y, or Z, right? I mean, I don't think it's inconceivable that would be quid pro quo, but it is a little outside of sort of the traditional concept of, like, in the employment concept where you have a supervisor and a direct report, for example. But, you know, I do think there's lots of room in the student context for student. I mean, another example would be, what if you got a student who's a TA, a graduate student who's a TA, and they're grading papers and whatnot for a class, and you got another student. You could easily have quid pro quo there, even though they're both students. Let's see. Can you explain the effects of a student pursuing remedies in the courts after a decision by the school's adjudication process? Well, depends on what they're pursuing, right? If they're pursuing the respondent, and they're trying to get some sort of damages from the respondent, and they're suing the respondent. I don't know that there is any immediate implication for the school, although certainly a potential outcome would, if they're not joining the school to the case, potential outcome would be, though, if the respondent's victorious and the respondent was kicked out of the school, you could then get sued by the respondent, right? Who says, well, you know, when a fulsome, and that's what's happened in the last 3 or 4 years, is you've had this string of cases where respondents have been successful against schools, and courts have said you're not giving them enough due process, right? That's been one of the big challenges. But the other question here could be, you know, do you mean what happens if you get through the adjudication process and let's say the complainant doesn't feel like the resolution was sufficient or the respondent, and they sue the school on the basis that the school violated its obligations under Title IX for monetary damages. I mean, yeah, they could do that, and that's happened in those 2 Supreme Court cases that we talked about at the outset. That's what they were considering. You had individuals who had been at the school and sued the school for monetary damages on the grounds that the school did not fulfill its obligations under Title IX. Let's see. Does an employee have to choose between adjudication through Title IX or Title VII? Yeah, that's an interesting question. I don't believe so. Again, I'm not an HR attorney. I mean, so I haven't really thought a lot about. I don't do a lot of Title VII exclusively kind of work. Most of mine is in Title IX. But I'm not sure why pursuing some sort of outcome under Title IX would necessarily obviate the opportunity of the employee to either simultaneously or independently try to achieve some sort of resolution under Title VII. But, you know, I mentioned earlier, I mean, the department, they're very clear here, actually, and they include in the proposed rule some language, and this is at the very end of the presentation, that, you know, these rules aren't intended to prevent an employee from being able to exercise rights under like collective bargaining agreements and things like that, and under Title VII. So, I might have to think a little more about it, but I believe that this is precisely what the department's language is getting at, is that, you know, the function of these rules is not to remove any rights of the employee. It's also worth noting, and sometimes this gets forgotten, that the Title IX and all of these obligations are obligations of the school. Title IX does not place obligations on employees or students, right? I mean, it's the school's obligation to take action when sexual harassment has actual knowledge under these rules of sexual harassment. So all of these obligations are obligations that flow to the school, and it's hard to see how the school exercising its obligation and carrying out its obligation could or should somehow prevent or impede an employee from pursuing rights that are provided to them under a separate federal law. So my answer here, my gut is no. But again, I haven't taken a great time to look at it. Ask your attorney. That's almost all the questions. There are 2 or 3 others that we didn't get to, but really appreciate folks tuning in. Encourage you to go back and check out some of our past webinars. I will also add, for the folks who are still on the line, we are expecting some additional guidance from the department on some of these other regulatory initiatives around borrower defense in particular in the coming weeks. And if it arrives, I will probably try to do not part of the webinar series, but just a one-off webinar in December to cover that guidance and to talk through it a little bit. Hope everybody had a great Thanksgiving. Hope you're all staying out of the weather and safe. And I encourage you to look at this stuff, absorb it, and keep track of it. And hopefully the presentation was helpful. Have a great day. Talk to you later. Bye.